Yeah, well, it's AHB too. We were talking about that this morning. 151. I'm old enough to get another job.
Well, I just want to thank you all for coming and joining us here today for Working for Racial Justice, the Racial Justice Improvement Project of the American Bar Association. I know there are a number of breakout sessions, and you guys chose to come to the best one. Exactly. So I just wanted to thank you all. My name is Selma Safadine. I am the staff attorney for the American Bar Association Criminal Justice Section. I'm also the associate director of the Racial Justice Improvement Project. I work very closely with Jack Hanna, who's the director of our Criminal Justice Section of the American Bar Association, and he was unable to attend. However, another individual that I work very closely with is Cynthia Jones, our project director, who's to my right. Cynthia Jones is actually a tenured law professor at American University, Washington College of Law, and she teaches evidence, criminal law, criminal procedure, and race, crime, and politics. She recently received the American University 2011 Faculty Award for Outstanding Teaching, and she currently serves as the chair of the Board of Trustees of the Public Defender Services for the District of Columbia, and that was following being the executive director of Public Defender Services for DC. She, like I said, is the director of our Racial Justice Improvement Project and pretty much the mastermind behind our 4 task forces. To her right, we have Fred Friedman. Mr. Friedman has been an attorney since 1972 and a public defender in Minnesota since 1973. Fred has served as the chief public defender in Minnesota's 6th District, northeastern Minnesota region. And since 1986, he has held that position and is Minnesota's most senior public defender today. He has been annually selected as one of Minnesota's super lawyers, and he also has received a number of outstanding teaching awards. Fred will actually discuss his role in the task force as a public defender, and momentarily I'll discuss what those task forces are and what jurisdictions we have chosen to be part of this project. To Fred's right, we have Donna Ennis. She is the Eastern Regional Director for North Homes Children and Family Services. That's a professional foster care agency. For more than 20 years of experience providing services to families and children, she's a licensed social worker in Minnesota with specialized expertise with minorities, specifically Native Americans and African Americans. She serves on several boards, including the Duluth American Indian Commission, and she's a member of the Fond du Lac Reservation, which is an Ojibwe tribe in Minnesota. Ojibwe. I knew I was going to butcher that. I asked her before we got here how to say it, but I butchered it. We know what you meant. Thank you. I appreciate that. So she actually is our community representative for our Minnesota Task Force. So I want to take a step back and just give you a project overview of our Racial Justice Improvement Project. The Racial Justice Improvement Project is a project that the Criminal Justice Section of the American Bar Association has taken through a grant that we received with the Bureau of Justice Assistance. Through this project, we chose 4 jurisdictions: New York, Louisiana, Delaware, and Minnesota, and we required that each of the jurisdictions that we chose formulate a task force. And the task force had to be composed of the chief defender, the chief of police, the chief prosecutor, the chief judge, and a community representative. And all these 5 stakeholders had to be at the table in order to formulate the task force and be part of the project. So each of those 4 jurisdictions do hold a task force. With that task force, they were then assigned to choose a reform that was, choose a racial justice reform that was supported by data that could be implemented through a change of policy or a change in practice. So we weren't looking to do statutory reform. We were just looking to somehow implement a reform that would allow us to make a difference on the policy side. So each of the task forces created a honed-in interest area, and then set out to collect data and then analyze that data to determine the extent of the racial disparity in that jurisdiction. Cynthia Jones is going to talk about what area of reform each of the task force members chose, but before she does that, I am going to talk about a little bit about another sister project that we have at the American Bar Association, our cultural competency curriculum and instruction manual.
Why don't we save that for the end, because I think it's going to tie in with some of the other things we're going to talk about.
Okay, so then I'll just hand the floor over to you.
Okay, thank you. Again, welcome, and I wanted to give you guys a broad overview. If nothing else, what I hope everyone takes away from this is an approach to dealing with racial disparities in the criminal justice system. There have been numerous efforts and lots written about, that they exist, that, Native Americans or African Americans or Latinos are pulled over by the police at a higher rate and they're incarcerated, their sentences are longer. What we're trying to do through policy is to come up with a group of people who can actually change the way the criminal justice system does business. So, for example, it's okay. So, the Racial Justice Improvement Project, by getting together those stakeholders, because in the criminal justice system, and how many of you work in the criminal justice system in some way? So those of you who work in the system know this. There is no boss of the criminal justice system. There's no one person who can control what the judge does, what the prosecutor does, what the police do, what the public defender. No one is over all of them. So in order for there to be criminal justice reform, they all have to come together. The police officers have to do certain things, the prosecutor has to agree, and the judge has to enforce it, and the public defender all have to work together. And this task force was designed to bring together people who were stakeholders and policymakers who could simply change the way they do business and affect racial disparities or eliminate them. And the example I gave when I first came on board was consent searches, right? The law of consent searches, that is, a police officer pulls a car over, and when the police officer pulls a car over for speeding or for some other reason, the officer can conduct a very limited search of the car. They cannot go in the trunk unless they have probable cause. So in order for a police officer to go in the trunk of a car, because he's pulled over somebody and he's going to give them a ticket, they would have to consent. They disproportionately ask for consent from minorities, and they disproportionately search minorities. Now, if you wanted to pull someone over and it was racial profiling, you would have to rely on consent searches because you actually didn't have a legitimate reason for stopping them, and you therefore would never have probable cause to go in response. So to get at the problem of racial profiling, you could do several policy things to address consent searches, because they would never have any basis to bring the marijuana that they found in the trunk into the courts. If you simply either did not do consent searches, the police department, the chief of police could simply say to his officers, no more consent searches. If you stop someone, you want to give them a ticket, do not ask for consent to search, and don't search their trunks unless you have probable cause. They could do that. As a matter of policy, you don't have to change the law, they could do that. Alternatively, as they do in Austin, Texas, you have to sign what is sort of like a Miranda form, right? The law of the land is consent doesn't have to be knowing, intelligent, and voluntary. That is, the police officers do not have to tell you of your right to refuse to give consent. But in Austin, Texas, they can give you more rights, and they say you have to sign a form. In California, they did a moratorium on consent searches and tried to prevent people, police officers, from conducting these kinds of searches. And in another jurisdiction, in Rhode Island and in Minnesota, before the police officer can ask you to consent to a search, there has to be reasonable articulable suspicion. That is the same standard that's required before an officer can frisk a person, right? So there are things that can be done as a matter of policy. The police officers could say, we're not going to do it, or the prosecutor's office could say to the police officers, if you conduct consent searches and there's no reasonable suspicion, no basis, we're not prosecuting those cases.